I think we can make a start. Well, first of all, thank you to the previous speakers for those amazing contributions. That was incredibly impressive, and congratulations to the winners. So I hope we can at least match them if we possibly can, which is a very high bar to set. So if I can just introduce my very esteemed colleagues who are going to be giving the panel discussion this afternoon. Start with Giorgio Ferni from Delix, who is a lawyer who specializes very much in collective actions, competition law, consumer law, but is also an academic at the University of Genoa, so we're very lucky to have him. Next, Roberto Alamonte of Auxera, so he's a consulting economist here in Rome, very experienced across a whole number of different industry sectors and very experienced at quantifying damages, so very relevant to today's discussion. Moving to my left, Ginny Bicchiolo, who's a senior lawyer at HAUSFELD, specializes in competition damages claims, very much from a claimant perspective. Recently been through a trial on high voltage cables, so has that very relevant and recent experience of trying to quantify something in the English courts. And last but not least, Giulio Trajano from our London office, senior associate, again, specializing in competition damages claims, very much with a tech focus and a specialization in AI. So today's topic, and we've only got 45 minutes, is to do with the quantification of damages in competition litigation, both in the UK and the EU more broadly. We're trying to do something comparative and get different perspectives from the different jurisdictions. We'll try and make a bit of space at the end for some questions, so please feel free to save those up. But we're broadly going to try and cover three areas. First of all, briefly looking at the procedure in the major jurisdictions and looking at the court's approach to economic evidence. Then looking at recent experience of use of different economic methodologies in the courts, and we'll look at some case studies and examples to illustrate that. And then finally, if we've got a bit of time, we'll look at pass-on as well, which is a perennial question we all have to deal with. So, to kick off, it'd be, I think, interesting to get a bit of the procedural background, maybe start with the UK, let us know how we do things there, and then try and compare it to elsewhere in Europe.
Thanks, Scott, and hi, everyone. So I'll make a start, and Julia obviously chip in. So as all of you will know, the UK has a very much adversarial process where each party instructs their own expert in litigation, and the I should also note that in the UK, in recent years, competition damages claims are heard in a specialist tribunal, so the Competition Appeal Tribunal, which is composed by a panel of 3 members, or at least a trial will be composed by a panel of 3 members, one of which is an economist. And so effectively, you have, the courts, are able to engage with kind of economic evidence of some sophistication. The duty of the experts instructed by the parties, though, is to the court. So they are not partisan experts in that respect. And from that derives all sorts of things, like, for example, they cannot act on conditional fee arrangements, etc. Not sure if I've forgotten anything else.
All I might add is it also extends to the way in which we communicate with experts a lot of the time and how we instruct them. But no, I think otherwise all covered off.
Thanks. And looking further afield to continental Europe, Roberto, I think you've got a few comments.
Yeah, sure. Thanks, Scott. And first of all, let me say thank you to HAUSFELD for having me here today. It's a pleasure to join you on this very interesting panel. And kudos to the Lair family for the impeccable organization of this event. So well done. The picture in continental Europe is quite fragmented, I would say. So typically the parties appoint their own experts. I say typically, I will come back to this point in a moment. And the courts can or cannot appoint their own experts. So that very much depends on the jurisdiction. I said typically because sometimes claimants, especially in small claims, they do not choose to be represented, or maybe they cannot afford having their own experts, and so sometimes they ask courts to appoint one for them. There is a tendency in some jurisdictions of courts relying quite extensively on their own experts. Giorgio will tell us more about Italy in a moment, but Italy is one such jurisdiction where courts tend to rely quite significantly on their own experts, including on the output of their work, so in the final judgment. Germany is pretty similar to Italy, I would say, is a jurisdiction where it's the use of court-appointed experts, it's almost becoming the norm, although you have, of course, instances in which courts do without. I understand, for example, last year, the Court of Berlin, the Court of Dortmund reached a number of judgments, including on technical aspects, without the use of a court-appointed expert. Or sometimes they do appoint an expert, but they don't explicitly rely on their work in the final decision. This happened, for example, on a trucks case fairly recently. I think at the other sort of end of the spectrum, I would probably put Spain, based on discussions with my Spanish colleagues in Madrid. I understand that in Spain there is a tendency not to use experts, so courts don't use them a lot. Trucks is one example where court-appointed experts are extremely rare. The system works in a different way. The sort of the expert proceeding phase works differently relative to Italy, for example. There have been some on the cartels case, but quite limited. And just going back to the point that you made, Ginny, on the duty of the expert. This sometimes comes up when chatting with legal practitioners or other experts from other jurisdictions, and the fact that in the UK economic experts have a duty to the court. This was actually a very interesting point that was picked up by the Competition Appeal Tribunal in the UK recently in the Royal Mail and MBT against the DAF, so one of the trucks judgments, whether the experts working for the parties were indeed showing a duty to the court or not. And the idea that in continental Europe that duty doesn't exist. I think that's a false dichotomy. That's my personal view. I think it's a false dichotomy because if my experience is that economic experts play, or at least aim to play, a repeated game. And in this repeated game, we often interact with the same courts, with the same judges, with the same court-appointed experts. And I think parties-appointed experts, at this point, given the visibility of the various judgments, as we will see, going, for example, through the various judgments on trucks, what a party-appointed expert says or does on a given case is observed in other jurisdictions. So, at least from my perspective, I think parties-appointed experts should demonstrate, or at least do their best to demonstrate independence, integrity when sharing the data and their analysis, sharing the full data pack from input to output, sharing and disclosing possible conflicts. This is something that came up on trucks in the UK, for example, this specific point. I think, so whether there is a formal duty to the court or not, courts, judges, and court-appointed experts internalize these. And the next time you face them again, and it's important, they, in one way or another, they attribute some value to those aspects. So you better, display these elements. Otherwise, in the next round of the game, there might be, implications. And I think maybe we can move to Italy.
Great, thank you. I would also like to thank HAUSFELD for organizing the panel and for inviting me. It's a pleasure. And also Lear for organizing the conference. It was, beautiful conference, so thank you very much. What can I say? In Italy, as most of you know, we have a system based on specialized courts. We have 3 courts, one in Milan, one in Rome, and one in Naples, and they deal with competition law. They're not really fully specialized court like the CAT, in the sense that they also deal with our other matters related to what we call industrial law, so there is copyrights or unfair competition. So they're not really fully specialized, and they don't do public enforcement. They just do private enforcement. But they are specialized, and they're only 3. Perhaps the most active today is Milan. And as far as the role of the expert is concerned, it's exactly as Roberto was explaining, in the sense that in Italy, each party has its own expert, and then the court appoints its own expert. So a party-appointed expert, they typically do not own a duty to the tribunal, but they merely represent the interests of the client. Of course, there are some provisions. They don't have to swear, for example. The expert appointed by the court must swear, but he's going to act loyally and say the truth, etc. And so typically party-appointed expert, they simply represent the interest of their client. I do agree with Roberto that they should try to remain within a region of reasonableness. And this, I think, is true both for claimant and both for defendant, because since at the end of the day, basically what happens is that when it comes to estimation of damages, it is as if the Italian court is delegating the activity of estimating damages to the court-appointed expert. So the party-appointed expert should anticipate that his interlocutor is an expert, as he is. And if he come out with some strange theory or with numbers which are completely not realistic, he would lose credibility also in the eyes of a court-appointed expert. So in theory, I do agree with Roberto that it should remain in an area of reason. It's not like in the US where you have the anchor effect that, the greater is the number you ask with a complaint, and the greater is going to be the award that you receive at the end. Because in the US you have juries, and sometimes juries, they compete on who award the greatest amount of damages, because jurors, they like to read on the newspaper the day after that a big blockbuster award. Of course, it doesn't work like this, and this is obvious. So I do agree with what Roberto is saying.
Thanks, both. In the last set of presentations, we saw some statistics about the number of cases post-damages directive, so I think that would be quite interesting to look at. How has the outlook changed, and have we seen any convergence since then in different jurisdictions? I don't know who wants to go first on that one. Yep, sure.
So I think it's fair to say that we have seen some degree of harmonization. So at least the way the basic rules, how to bring a claim, the general architecture as to what matters, the building blocks of damages quantification. There has been sort of a greater degree of homogeneity in that respect. And I think while correlation doesn't always mean causation, since the EU damages directive came out, we've seen an exponential increase in the number of claims. Obviously, other factors play a role, other competition policy instruments do play a role, but I think it's fair to recognize that some of the merit should be attributed to the EU damages directive itself. However, I think there is still some heterogeneity. There is still heterogeneity in the way the cases are handled across jurisdictions, and to some extent, I think that's conceivable. It should be tolerated. In fact, I don't advocate for perfect homogeneity. even the same cartel case or the same abuse can have different effects in different markets, in different jurisdictions, or against different parties. So some degree of heterogeneity, I think, is still desirable. But I do see a picture where there is still the possibility to do some significant forum shopping, and that heavily depends on the experience of the courts, the efficiency of the various courts across Europe, the approach that different courts and tribunals take towards things like disclosure, pass on. Sometimes I speak with my colleagues in Germany and they tell me that pass on is not really a big thing in Germany, whereas in the rest of Europe, you can't do without, right? You know, if you are on the claimant side, you really need to think about your pass-on theory, whether it would stand up to scrutiny or not. In Germany, it seems to be rather different. And I'm sure we can come back to this point later. And I think, you know, it's fair to say that if we take a snapshot right now at the current landscape, I still see far too many cases where overcharge is estimated by both claimants, which to some extent can be tolerated depending on the cases, and courts based on meta-studies, so these studies that look back at previous cartel cases and they aggregate the results, they show a distribution, and typically what people tend to do is to go in the middle, look at the mean overcharge, take that number, extrapolate it, and attach it to your case. I am perfectly conscious that one such meta-study is presented in the Oxera 2009 report that was prepared for the European Commission, and I still have a strong pain in my chest every time I see a judgment or an opposing expert referring to that specific bar chart, because the purpose of that was precisely to do the opposite, is to show the variety of overcharges that you can have, and even the fact that sometimes you have ineffective cartels, close brackets. Reference to meta-studies, reference to benchmarks, reference to arbitrary thresholds for overcharge. Pass-on is done in a very heterogeneous way. Rarely it's done in a very robust fashion, typically done by reference to the guidance provided by the Commission, so based on theory. That's typically due to the fact that there is still some reluctance to fully disclose evidence from the claimant, which would allow the defendants to build a robust pass-on defense. Interest. A lot of question marks on interest on damages, and not just on the choice of the interest rate, whether it should be the cost of debt, the cost of equity, the WACC, but sometimes on certain claims in certain jurisdictions you can add on top litigation interest, whereas in other jurisdictions you can't. The methodology, simple versus compound. On some cases you see the compound is allowed, in some other instances it's just simple interest statutory. The timing from when interest gets calculated. I think this is giving back a picture which is still quite fragmented. So I think there's still a lot of work that needs to be done to get to some sort of good level of convergence.
Yeah, I mean, we would all love to live with a 26% in the Oxera report when it comes to overcharge, but we're not seeing that so often, unfortunately. I mean, one of the best examples of a pan-European cartel that's been litigated in a whole host of different places is trucks. So I've spent 8 or 9 years of my life doing that, and it's still going on. It may well go on for a few more years, but Ginny, you were going to tell us about the case in the UK.
Yeah, I think, first of all, I just wanted to say I agree with the picture that Roberta's drawn. I think we should, and you see that in the way that kind of clients also approach you in terms of, you know, choosing where to bring their claim, where there is a choice of jurisdiction. But also, I think we should remember that only very few cases get to trial. And so, you know, there is still kind of a body of kind of precedents that is developing, and the occasions for it to develop will be still far and few in this sector. I think in the UK, for example, there's a huge kind of emphasis on settlement, which means that it is a sophisticated jurisdiction, but the judgments are very few. So one of those was the Trucks judgment by the Competition Appeal Tribunal in 2023. This was the first Trucks claim to be decided in the UK. It was the claim by Royal Mail and BT against DAF. And I don't need to explain what the Trucks cartel is about, which is a plus. But in summary, what the parties were arguing there is that DAF was arguing a 0% overcharge, and Royal Mail and BT were arguing a 10% overcharge. Both parties used econometrics. So both parties' experts used econometrics. And the judge, the Competition Appeal Tribunal decided 5%, so right in the middle. So obviously this judgment has been talked about a lot, but I think it's important to understand why the Competition Appeal Tribunal found what they found. So the tribunal found that the evidence adduced by the claimants pointed to the existence of an overcharge and to the existence of a loss to the claimants. However, the CAT, and by CAT I mean Competition Appeal Tribunal, the CAT criticized both experts' analysis because the CAT said they produced kind of two diametrically opposed regression positions, which effectively aligned with their own clients' positions, and which meant that obviously the experts were perceived to be partisan and to not concede on very reasonable points and not kind of help the tribunal by instituting a dialogue between themselves and kind of conceding on aspects where actually their analysis may have been a little bit short and the other experts' analysis may have been a little bit better. So the court said, in this circumstance, I cannot use a mathematical exercise and actually derive the overcharge mathematically, and so I'm going to have to wield my broad axe and just go in the middle. But it is really important to understand that the court hasn't just discarded the use of econometrics in doing so. It's more about how the experts have approached the task of regression analysis, really. So, not sure if...
So I think Julia was going to talk about pass-on.
I was going to talk about pass-on, which I can do now, or can move on to later. But I was mostly going to give an overview of that for the UK, just because I think, as you mentioned, Roberto, it's a very different position. And I guess for pass-on, really the most important judgment we had was more the Supreme Court one in Sainsbury's and MasterCard, where essentially the Supreme Court found that the burden of proof there was on Visa and MasterCard to effectively say, to plead and prove that retailers had mitigated their loss by passing this on. And the interesting thing there in terms of broad axe approach is that what was said is that defendants arguing this need no greater precision than claimants, so essentially the broad axe point would apply for both, but then where it is raised as a defense, ultimately it is not a strict defense because it's still within the context of there's been an overcharge and then you want to show pass on. And so we go back to the evidential question of what do you need as a defendant to prove that pass on has occurred? And also the broader question of what constitutes pass on. So in that decision, for example, the Supreme Court gave guidance and said, look, when there's an overcharge, a company can react in 4 different ways. They can either adjust the price, they can negotiate with suppliers, they can just absorb it, or they can rearrange essentially their discretionary spend. And only the first two, so adjust the price and negotiate with suppliers, count as pass on. the utility of these 4 categories was then queried later down the line by the CAT, because again, you know, from a definitional point of view, I think they made the point that there's a difference between how economists think of pass-on and how lawyers think of pass-on, and lawyers obviously are concerned with the causation and showing that there is a direct link. Economists might look at, for example, cost savings and how that plays out. So we go back again to the evidence and the difficulty that claimants, for example, have as well, in terms of you know, if you are an indirect purchaser and you're using pass-on as a cause of action rather than a defense, you're relying on disclosure to maybe identify board minutes, financial statements, but again, it's quite difficult to prove. Be that as it may, though, I think that the Supreme Court said correctly that just because something is potentially difficult to prove or quantify doesn't mean you should stop. And so, you know, it remains a really interesting topic.
So Roberto, I mean, what is the lived experience of economists within this context? You know, you've got sometimes divergent judgments within one country, and then it differs when you go into another country. You're operating across borders, of course. So how do you deal with that, and what are your takeaways from it?
I think trucks is a good example, right? Because we have seen a constellation of different analyses and different approaches. Ginny, you mentioned what happened in the UK. I think, you know, just to very briefly, before you get to your question, Scott, complete the picture. You have, obviously, the UK jurisdiction is quite advanced in terms of the engagement with the court, the use of economic analysis on the various building blocks. Other jurisdictions are quickly catching up, Spain being one of them. Trucks, for example, you have a constellation of overcharge results until the Spanish Supreme Court came in, both in the first wave and the second wave of claims, and said, you know what, I don't like meta studies. I don't think they're sufficiently reliable, but I think there is some damage. This cartel has resulted in some damage. So I'm going to say 5%, but I'm going to give the parties the possibility to either show me that it's higher than 5 or lower than 5. But they pretty much, I would say, finger in the air, set a bar at 5%. And I think, you know, the interesting takeaway of what happened in Spain is, first, the fact that they said meta-studies don't matter, they're not reliable. And I think, you know, if we compare and contrast that with what happened in Germany, for example, we would see some differences. Second, the Spanish court, the Supreme Court, looked at the judgment from the Competition Appeal Tribunal. So going back to the point of convergence, that indeed can lead to some convergence of approach across different jurisdictions. I also see some potential problems in case you anchor your judgment to a not particularly robust judgment by another court. Then you have cross-contamination across different jurisdictions, and I think that's problematic in general. Germany, after, I think, you know, again, a constellation of overcharges until the German federal court comes in and said in Trax 3 and Trax 4, and effectively says, Trax 3, it's nearly impossible to prove that there is no harm, technically. Trax 4, you claimants don't need to appoint an expert. The court, if the court wants, the court will do it. So you don't need to submit an expert report written by an economist. And equally, the court cannot refrain itself from setting at least minimum damages unless there is complete lack of evidence. So effectively, in Germany, there is now the impression that you can bring a claim without economist in practice. And I argue that, you know, there are some data points in France, in Italy as well, on trucks, very, very scattered, and I think, not particularly relevant for this debate. My take is I agree with the Spanish Supreme Court that meta-studies are not helpful. I do believe that if we want to achieve what is the clear goal set by the EU Damages Directive of reaching full compensation, so neither overcompensation nor undercompensation, the only tool available is economic analysis. Relying on meta-studies just brings a host of problems, errors in the quantification which can be substantive, strange effects on how competition policy tools would work, weird incentives in terms of what claims will be, the parties will have an incentive to bring in front of a court or not necessarily related on the size, linked to the size of the overcharge, but just on the value of commerce. And I don't think that would be a desirable outcome. As an economist, I think I don't advocate, Ginny, you mentioned in a number of these cases, econometric analysis was tried. In some cases, it succeeded, very few, very limited, of those where we can read the judgment. In most of the cases, it either failed or there was the broad axe from the Competition Appeal Tribunal. I'm of the view that our core econometric analysis should be desirable only in those cases where you have very complex theories of harm, very large and reliable data sets. If you have a long-lasting cartel with scattered data sets and poor data, then from the onset that any regression analysis you would do would lead to some shaky results. Then you can end up in the situation of Royal Mail, where you have two different models, the two experts arguing these three different factors should be tested this way. For the those interested in the audience, it was the impact of the financial crisis, the emission standards, and the exchange, how to convert currencies between one currency and another. The two experts that were using different methodologies. Those are very technical aspects. We are in the context of a litigation. I think it's fair to have opposing views between the two different parties, right? Litigation happens. Otherwise, there would be no litigation in the first place. And you have, different points of view in the academia and in many other fields. I think the key message that I would personally like to land is that we should try to avoid that the perfection becomes the enemy of the good. So if we have the perfect data set, if we have a complex theory of harm, if based on a cost-benefit analysis it makes sense to embark in technical, experimental, econometric analysis, then do that. But there are other techniques, simpler techniques, that if you ground on solid assumptions, they would still work, and they would still be better and lead to better outcomes than relying on a finger-in-the-air meta-study.
Yeah, I mean, it always strikes me as a major determinant in how you approach these cases. If you've got access to disclosure from the defendants, so what you can do in the Netherlands or Italy might be very different to England and Wales in terms of the complexity of the analysis. So I don't know if you want to make a few remarks about that, then we can pass on to Giorgio to get the Italian experience.
To me, disclosure is an important aspect. I see that as a big barrier when you are working on the D side, on the defendant side, and that sort of complexity comes in loud and clear when you try to build not so much your overcharge story, right? You can still articulate and engage with the model and the analysis that is done by the claimant to some extent. The real complexity comes in when you're trying to build the architecture of your pass-on defense. If you don't have a sufficiently good disclosure, then defendants would find themselves in big trouble, and sometimes you can rely on qualitative evidence. There are instances in which qualitative evidence played a role. There is this sort of decennial insurance cartel in Spain, where, for example, due to lack of evidence disclosed by the opposing party, The defendants managed to convince the court using using documents, effectively, that the pass on would have been automatically, contractually passed on in the price of a house. And there would be no volume effect because that was the boom of the house market. I recognize that possibility in Italian courts as well. There are instances where, for example, in the construction sector, you read a contract and you see that there is a clause that if the input price goes up, then you're allowed to pass on that increment to your purchases almost automatically. But to me, that's the area where disclosure becomes really problematic.
Yeah. What can I say? Well, in Italy, I would say that private enforcement is quite developed. There are not many decisions published yet, but there are many cases pending. And I would say many court-appointed expert opinion were not published, but were handed down. So we have an idea of how things are working. And I mean, big cases are the truck case, of course, which has been extensively litigated in Italy, the cement case, and now the cardboard case, which is a huge case, which is, I mean, it's going to generate a lot of litigation. And I would say that perhaps the biggest difference, I mean, for the truck case, if you take the truck case, for example, there was no class action on the truck case because at the time the class action was available only for consumers. And so what happened is that you had many individual claims, low-value claims, and some big joinder of claims cases. And I think there is a huge difference, and apologize if I say something obvious, but there is a huge difference between these two kind of cases, both on how they are approached by claimant, but also on how they are approached by the judge and by the court-appointed expert. Because, for example, for a low-value claim, I mean, would be inconceivable to run a regression analysis or to do something sophisticated. So claimant typically rely on an ex aequo bono evaluation or in these meta studies like the Oxira studies. And then the outcome is very unpredictable because if you find the right judge or the right, from the claimant point of view, of course, the right judge or the right court-appointed expert, you can get a lot. So, for example, there are some decisions from Naples which awards 15% overcharge. But if you have the wrong judge or the wrong court-appointed expert, you can get nothing. And so, I mean, on the other hand, I mean, big cases which today they would be run through the assignment of claim model. But for the truck case, I think they still use the traditional joinder of claims. In big cases, everything is done properly, of course, so the claimant has a good regression analysis, a good expert opinion based on a regression analysis, and should reasonably expect that the judge will appoint an expert with the required capabilities and with the required expertise. And of course, this is something sometimes happens, sometimes no. So there is some risk on how expert really is the court-appointed expert. And when everything goes well, and in some cases this, of course, has happened in the truck case, then typically I would say there is a trend to 5%. So in this sense, Italy, at the end of the day, is aligning to all other major jurisdiction, perhaps following the lead of the UK. But the fact that there is alignment between in this big European Union, international-wide cartels, the fact that there is an alignment between different jurisdictions, I don't think should come. I'm not sure it's something bad, because it's true that there must be competition between jurisdictions, but this should not be on the level of overcharge. It should be on different dimensions like efficiency and reliability and quality. And I think so I don't think it's something bad. I don't think it should come as a surprise, because at the end of the day, the judges, they know each other. They talk to each other. Like I was mentioning, Peter Rowe, for example, who was the former president of the Competition Appeal Tribunal, is always in Italy because he likes Italy. So 2 weeks ago I met him in Madonna di Campiglio at this beautiful meeting organized by Michele Carpagnano. Friday he's going to be in Florence. Actually, I'm surprised that he's not here today. And they talk. They talk. There is also an association of national judges dealing with this is something good. It's a learning by doing process, and I tend to be an optimistic person, and I think things are really improving everywhere, but also in Italy. What else can I say about? But again, we are somehow in Italy at the beginning, so you don't really see very sophisticated analysis yet in court decision, and perhaps we have good example on the passing on defense, which is of course very problematic. I remember when I was a young student, I used to study, I studied passing on, and I remember, I think it was Richard Posner who described passing on as a statistical nightmare. So really to estimate passing on, I think it's extremely complicated. And when Italian judges are faced with this problem, they tend to take shortcuts, which I think makes sense to a certain extent. And so, for example, they either deny passing on because it was not proven, and this, for example, happened in the cement case, where perhaps because in the cement case, when the claim was filed by a purchaser of cement who was producing concrete, who then was resold to companies that build houses or bridges or whatever. I mean, I do understand there must be some passing on, but there are some cases where the judge say no. I mean, passing on was not proven, or you also have other cases where passing on was not was considered, and again was excluded because of the and here I'm referring to the steel cartel, because of the impact of the cost of the cartelized good on the total cost of a good that was produced. And again, but also here we see some convergence. For example, in the truck case, the tendency is 5% and no passing on.
Great. So we can't stop talking about ourselves in the UK, so I think we've got a few reactions based on some of the cases other than trucks that we've been through. And then we've probably got a couple of minutes for a final couple of remarks on pass on, where you've got claims from different parts of the supply chain. And if we're lucky, we might have a few questions at the end.
Thanks, Scott. Yeah, I just wanted to react to a couple of things. So I think, obviously, in the UK, we have lots of disclosure, and that is why litigating is expensive, and that is why there's a level of sophistication that probably, hasn't been achieved yet in other jurisdictions. Now, I think, to your point, Roberto, of the regression analysis being preferable, being, a tool to robustly assess, the overcharge. I think, obviously, regression analysis is very much, econometrics generally is very much accepted by the UK courts, and they can engage with it. But there is a tendency also of the CAT to prefer simplicity and to prefer analysis that they can effectively engage with and can write judgments about as well. So, the sophistication is there, but there's, I would say, an increasing trend to try and ground the experts into the reality of the facts of the case. And, for example, picking the variables in a regression analysis that actually reflect the factual witness evidence, for example. So there is a drive to simplify the process to the extent possible. There is also I think that's all I wanted to say. That it's again, I don't think the simplicity is given by the broad axe and just kind of the judge kind of waking up one morning and deciding it's 5%. But it's more about kind of rejecting that kind of sophistication for the sake of sophistication and actually driving the expert to be independent, as we've discussed, and also driving the expert to actually engage with the facts of the case and not kind of put in a lot of variables just because, you know, it makes for a more robust models. They need to be variables that make sense. They need to be parameters that make sense in the realities of the case.
Just one very small thing to add. I think it's also the simplicity and the narrowing down is also borne out by the joint expert statements or the drive for those. So to narrow the issues down, to really get the experts to say, we agree on this issue and not on this issue, and where the nuance is, again, to kind of streamline things. And then the only other small thing that I was going to add, which leads back to passing on, so then we can kind of move back onto that if we can. But it's just that, you know, from a case management point of view, I think the CAT is also quite interesting because it's handed down orders in Merrick's, for example, where they say, we're not making any findings of fact, but this is how the tribunal would approach pass on in these umbrella proceedings, and then explained it without a finding of fact. So I think there's all these interesting aspects that go beyond just the, I guess, the analysis itself, but help with the simplification.
So final word, Roberto, to wrap up.
So on the toolbox and the different methodologies, I think econometrics is more complicated. It seems like, you know, a black box where you can effectively produce whatever you want. But just a comment on that. I think other techniques, even simple diachronic or synchronic analysis, can be prone to data manipulation if you want, to do data mining, or so. If you extend, you encompass one extra year in your counterfactual, you can get completely different results. And I see that all the time when you engage with the court-appointed experts. Depending on the evidence that's available, you try to introduce more evidence. The other party doesn't want more evidence because they fear that if you extend the counterfactual, you get different results. So I think, you know, and just from an economic perspective, every methodology can be in some way manipulated. You can manipulate the results. I think what is important is to, however, you know, whichever methodology you pick, is to ground it in the facts of how the market works. Econometrics has the advantage of, given that, you know, we live in a very complex world where the variables that we want to measure, prices, quantities, innovation, variety, quality, they are influenced by many different factors, and not just by the infringement. So that's the advantage of econometrics. But then you have, if you use it, then you have the additional burden of explaining exactly why all the variables that you put in the model are necessary. And equally, if you're going for a very simple analysis, you should probably build around your central results some confidence intervals, which, you know, should account for some margins of errors, because maybe you're not factoring in cost shifts, demand shifts that you would otherwise be able to, you know, measure more analytically using a regression analysis. Just a final word on pass-on. I think pass-on, I don't get any more intimidated by the analysis of pass-on relative to how to calculate interest or how to estimate the overcharge. After all, we are always trying to estimate something that has never existed. So there is always that sort of level of complexity. Pass-on brings in some tensions, I think. We operate in a world where the EU damages directive is telling us effectively two things. One, to work and be guided by a principle of compensating just the damages, avoiding overcompensation and undercompensation. The second one is the efficiency, is the effectiveness. We cannot overcomplicate and make it impossible to estimate the damages. And here I see a tension, because in reality companies are multi-product, they're multi-client, and they try to find ways to pass on a cost shift in many different ways. They don't just pass on the cost shift on one product. They can spread it across. They can do it in an uneven way across customers or product lines. And that makes the analysis of pass-on inherently complicated. And I think, it puts some difficulties in the court of the judge, because the judge will need to decide whether to run into the risk of giving some extra damages, so overestimating damages, or to just wait for a nebulous group of indirect purchasers to materialize. And I think, that's one trade-off. The second trade-off is that because you can have also indirect claims, then there is an issue of consistency of pass-on. So in my view, when I see, the broad axe approach being used by courts, the broad axe is not what we need to ensure that, there is consistency of calculation along the value chain. If you have multiple claims brought by different parties along the same value chain, and you start using the broad axe approach, chances are that you're not going to be able to find results that, are able to reconciliate with each other. I think, in the UK, there is one, and I don't think in that specific area, economic analysis can offer one single instrument to solve that problem. In the UK, there is this rather innovative tool which is called umbrella proceedings, where effectively you bring in different proceedings under one host case, and you deal with those possible conflicting issues under just one of them. So if you have multiple claimants along the same value chain seeking damages, then you bring the claims together and you assess them in the round. And I think, that's a pretty good approach, I would say.
Well, I think the defense of pass-on is a problem, because it undermines the incentive of a claimant to bring the action. And I do understand that you don't want to overcompensate the claimant, but you should not even leave to the cartelist the profits he made by participating to a cartel, because there is also an issue of deterrence. A solution I like is the German solution that perhaps you mentioned, that the German courts, in order to decide whether to allow disclosure to prove passing on, consider also the likelihood that indirect purchasers will go to court. And I think this is a good balance, because at the end of the day, it's much better to enrich the direct purchasers who was the victim of a cartel rather than the cartelist. And I think this is perfectly coherent also with the principle of effectiveness. And so I like that solution.
Okay. Always good to end on pass on. There's one question there.
I have some comments on what Roberto said. The first thing on the meta-studies, I fully agree with you that claims should not be based on meta-study, but at the same time, I really don't understand or don't buy the Spanish Supreme Court position, because I wonder where the 5% come from. At least if you have a meta-study, you have a study. If you think that you can make mistake, you can decide to use a mean, a conditional mean, so you can condition the mean on many aspects that you can see, which is something that is to some extent better than the gut feeling of the Supreme Court judge. That's my view. So either we say, we have a standard of proof, and if you rely on a meta-standard, on a meta-study, the standard is not reached, and so we deny any compensation. Okay, I can understand that legal position. But if you decide that there are damages, the meta-study is already something better than the educated guess of some uneducated people. All right, so that's the first point. Second point on econometrics, I think we should be fearful using econometrics. Definitely, I do understand that we need good database. I don't think we need the complex theory of harm. I mean, the theory of harm is simple. We can use econometrics. We should use econometrics, especially if we have a very simple theory of harm. And the broad axe principle is inevitable. Even if you use econometrics, you're going to use the broad axe at the end of the day. But the court said you have to use sound imagination and the broad axe. And econometrics is a way to get soundness in your imagination. So it's not that you have the magic results that provide you with the precise figure of the overcharge, but it's a piece of information that can be very, very helpful. So we can combine that with other techniques, simple techniques, if we want, but we shouldn't be afraid of using econometrics to the extent that this is possible if we have the data. And the final point is, a point that I always make. I always confront with the other party's expert, and the level is incredibly high. So I'm always happy to read your report. Hope you share the same view reading my report. But when I read the court-appointed experts' report, this is really frustrating. So the quality of those experts is definitely too low, and we have to do something to change it. Thank you.
I'll start from the last word, which I completely share. It's quite disappointing in certain jurisdictions where you spend a lot of time and effort, and then you encounter a very poor quality analysis. And the selection of the court-appointed expert should be done based on the background, and I generally, believe that in Italy, it's just the pool of people. There are exceptions, of course, so I don't want to generalize. And I found some, good court-appointed experts in some instances, but the vast majority of them produces very low-quality type of work, which is something that definitely needs some improvement. I didn't disclose this at the beginning, but I was lucky enough to spend some time working with Paolo at Lear when I started at the beginning. So it's definitely a pleasure to read your reports and those of your colleagues. On the use of econometrics, I agree. Econometrics, I think it's. If you are on the claimant side, then probably it's a bit more complicated, because even if you have the data by it's a relatively small case, claimants are sort of worse off in terms of. I think the right answer is it depends. It depends on the value of commerce. It depends on how cost effective it is at the end of the day. Yeah, that's it.
Yeah, just had a few words on Paolo's comment on let me say, the 5% issue from a lawyer's perspective. We have a situation in Italy where I think we have very good lawyers, expert in damage action, very good economists, expert, specialized court, as Giorgio correctly reminded. My point is, are we sure that we have judges, enough experts for this kind of cases? And I don't want to put blame on the judges, but more on the system. If you think that after 3 or 4 years that judge make experience in the division of, in the section of the court specialized in antitrust damage court, they usually are moved to other office, and then you get in the same case a judge coming from another office of the court dealing with real estate or family law issues. Then, if you have a poor quality on the court expert report appointed by the court, an expert which is not 100%, let me put it this way, expert on this kind of cases, the result is what you, Giorgio, correctly remind, the shortcut. The shortcut is not only on passing on, but sometimes in let's say, the liquidation of damages. And so the 5%, it's an issue not only because it's discretionary, probably not fairly linked to the economic assessment. And what happens when you have to deal with this liquidation in the Court of Appeal? You have to challenge a defense based on what? So it's also a matter of right of defense of the party.
on the meta study versus 5% finger in the air, and this is my personal view, tend to agree. I think the risk that we run into is that at some point these meta studies will become completely pointless. Completely pointless, because if people keep referring to either putting their finger in the air and saying it should be 5%, and then you can challenge that, or it's 15% because that's the average. At some point, as more data get collected, that distribution is no longer reliable. Assuming that it was reliable before, those meta studies sometimes have a selection bias, so you don't have full visibility of cases, they have all sorts of issues. But even assuming that the original distribution was okay and reliable, which is not, then you would run into the risk of effectively creating a bunch of 5%, a bunch of 15%, and what would happen at the end, I really don't know. I think, for some claimants, as a starting point, I can see the usefulness of saying, in the past, this is what happened. It's likely that this long-lasting cartel had some effects, but still you will need to prove them, and maybe, the court can appoint a capable expert. But I think at some point soon, these meta-studies will either disappear or will become completely pointless.
Just very quickly react to something that Paolo said about adopting more techniques, triangulation of findings. And that is something that in the UK, there's definitely an emphasis on that. And I think that also avoids the kind of, choosing the method that gives the highest overcharge, because, obviously in the UK, that's not what should happen. But if you do have a method that shows a high overcharge, but you have, kind of two other methods that you've used to kind of cross-check, even if they show a bit of lower overcharge, but still a very significant one, then that is something that has been very convincing, for kind of the Competition Appeal Tribunal. And generally, it is something that gives you comfort as a practitioner and, as kind of the lawyer of your client. So that is something that definitely we, from a practitioner point of view, from a lawyer point of view, we test our experts a lot with.
Okay, it feels like you've been very generous with your time. We've gone about 15 minutes over. There's just so much to talk about. I think there's a coffee break, or what remains of it, to continue the conversation. Forget about 5%. Thank you for the 100% given by the panel, and join me in thanking them.